Hey everybody, it's Bob Crossan, Senior Managing Editor for Water and Waste Digest. Today I have with me Claire Collins. She is a partner at the California law firm Hanson Bridgett, and we're going to be talking about SB 323 in California, what that means for water utilities in that state, and how it may impact conversations for ratepayers and whatnot as well. So let's get right into it. Claire, thank you so much for being here. I really appreciate you taking the time and talking to us about this subject.
Thanks for having me.
Yeah, well, before we get going, why don't you tell us a little bit about Hanson Bridget, about yourself, and what you do, so that we kind of know the what we're talking about here. We'll talk a little bit about SB 323 in just a second, but let's get some context around what you do as well.
Sure thing. Well, my name is Claire Collins, and I'm a partner at Hanson Bridgett. We're a California law firm. We have a specialization in government work, especially special districts and especially water and wastewater. So this is our bread and butter, what we do. We have about 36 attorneys who work on government-related matters, including construction, infrastructure of all types, finance, and general counseling, which is what I do. And I'm general counsel to Irvine Ranch Water District, Trabuco Canyon Water District, and West County Wastewater, all of which are handle wastewater, and Irvine and Trabuco also serve potable water to a relatively large portion of Orange County in California.
Great. Well, that gives us a lot of understanding, and thank you for helping out these water districts and wastewater districts. I'm sure that they appreciate your work just as much as we appreciate seeing it as well. Could you explain a little bit about SB 323 in California, and what that does mean for the utilities that you are general counsel for and other ones throughout the state?
Sure thing. So SB 323 was authored by the Association of California Water Agencies in association with a number of member agencies. And the purpose of it was to shorten and create predictability with respect to when agencies can be sued over their rates. So what it ultimately does is it shortens the statute of limitations, which is the period of time during which an agency can be sued. It shortens it to 120 days. Previously, it was relatively unclear how far out a challenger could go. And we recently had a case where rates were challenged that were a decade old or older. And when rates go that long and then are challenged, it creates an enormous amount of exposure for public agencies if there's an adverse ruling. And so this creates a lot more predictability for budgeting, and it creates a lot more predictability for rate setting. And it gives the agencies a more or less immediate view of whether or not those rates are going to be challenged within that 120-day period.
Mm-hmm. No, we were talking a little bit about before this call, kind of like what this means. We had you had mentioned this aspect of like these bounty hunters, so people actually going out with the sole purpose of kind of profiting off of this particular issue. Could you talk about that practice and what that meant for for utilities, and how this kind of alleviates that problem? Obviously, this 120-day thing makes a big difference, but.
It does. It does. You know, there have been a number of plaintiffs' lawyers in the state of California who have taken advantage of what's called a private attorney general statute, which means that in certain instances, attorneys who challenge these laws can basically make a payday. If they win and they can prove that they were pursuing the case in the public's interest, they can then seek their attorney's fees. In the grand scheme of things, if they are successful, it is only picking the ratepayers' pockets more. And here's why. In most of the cases where these plaintiffs' lawyers, these bounty hunters are successful, it ends up providing pennies in refunds to the ratepayers, but it provides millions to those attorneys. But who's going to pay those millions? Those millions are going to be paid again by the ratepayers. Public agencies don't have any other source of revenue than the ratepayers themselves. To some extent, they may be the beneficiaries of some portion of the property tax revenue, but in general, water and wastewater utilities are funded significantly or exclusively by ratepayer revenues. That means that if a bounty hunter attorney comes in, litigates successfully, collects $500,000 in refunded fees because they argued that they were allocated incorrectly, and then gets $2 million in attorney's fees, all that we're doing is we're moving around all of the fees among different ratepayers, and all those ratepayers are now paying that $2 million in attorney's fees. So there's a purpose behind being able to have a challenge, and that is that each and every ratepayer has the right to challenge whether or not the rates were set constitutionally, which means that they have to be proportional to their use, and they have to actually be users. As long as we meet those two standards constitutionally, it's significant, it's sufficient. These bounty hunter lawyers look for tiny technicalities and then take advantage of that in order to enrich themselves, really not in order to help the ratepayers. And if it comes 10 years later, after the rates were adopted, then you have to go back 10 years and reallocate all of the charges that all of our ratepayers paid. So that has been real trouble for public agencies, especially over the last 10 years. And this law still allows folks to challenge if there is something inappropriate, whether folks actually didn't use the service or if it really wasn't proportional. They still have the ability to challenge it. They just need to tell us, water and wastewater agencies, early, so that we can make the change, so we can make that fix, which is what we want to do. Our job as public agencies is to create reliable, safe utility service at the lowest reasonable cost, and that's still what we're doing.
Yeah. Well, I'm just imagining the tremendous burden that would place. I mean, you're talking about 10 years of billing cycles with, depending on the size of the utility, this could be an enormous project that, like, not only do you have the payout for the attorney's fees element, you also have to pay people to do the work to answer the questions in that 10-year period of billing. That's a tremendous burden for a utility, and especially right now where most utilities are very cash strapped and are very low on employees to do this type of work. It's astronomically difficult. It's crazy.
You make a good point. The administrative burden of litigating these cases is really significant. It's significant for the attorneys. It's significant for staff. We recently had a case that involved hundreds of hours of document review in order to provide documentation and respond to the request from the plaintiff's attorney. And in many cases, these are carpetbaggers. These are attorneys who are from areas they don't even live near. We recently had a case filed by 123 putative plaintiffs against 80 water agencies across the state of California. And the amount of attorney's fees generated in that case is so significant. And the case ultimately did not result in any benefits to ratepayers. But it did result in a really humongous amount of burden on all of these public water agencies. So we are trying to maintain ratepayers' constitutional rights to check and balance their government, which is an absolutely important right and one that we all stand behind, but to do it in a reasonable manner and in a reasonable time frame so that these public agencies can have some predictability about their budgets and about their rates.
Yeah. Well, and I just want to note as well, just tying this into some other things that we hear about within the industry from a trend standpoint, there are these constant conversations or this underlying network of conversations around equity, affordability, and access. And feels very directly related to that. As soon as you get these lawyer fees that have to be paid and that gets passed on to the ratepayers, suddenly it's no longer affordable. It may not be equitable. There's a lot of factors that play into that as well. I did want to move on to talk a little bit more about some of the elements of this laws too, because part of this is the reverse validation actions. I'm not very familiar with this, so I wanted to have this clarified for our audience as well. Could you explain what that actually means and how what that means for water utilities, especially in California, where this law is in effect?
Sure. Let me talk a little bit about the mechanics of SB 323. So what this does is it adds it adds a new provision to the law. And what it says is that after a rate is set, and we set a rate for something called a Prop 218 process, we send out notices to everyone at least 45 days before a public hearing. We hold a public hearing, and we allow folks to give us comments and to potentially challenge that rate. If less than 50% of folks challenge that rate, and usually we only get very few, literally, a few, dozen at the most. But if we get less than 50% challenge, then the board can vote to adopt the rate. And then there is a period of time from the effective date of the new rate for 120 days. That is the period during which it can be challenged. Under California state law, it's very typical to only allow for something called a validation action in situations involving public finance. So bond issuances, for example, are subject to I think it's a 60-day statute of limitations to challenge. But the method you go through is through a validation action or a reverse validation action. A validation action is when the agency that issued the bonds or adopted the rates basically files suit against all the property in the district and says, we want to confirm legally that this is valid. They go to court. If no one challenges, it becomes validated and it's beyond challenge. A reverse validation action is brought by someone against the agency and says, we want to invalidate this action, and therefore we are suing on behalf of all of the ratepayers to invalidate it, and it's a different process. So it's a different process than normal litigation because validation is its own portion of the statute of the Code of Civil Procedure, and it is commonly used for finance issues related to the government. So it's very specific. And it's comprehensive, and it's a known way to challenge or to confirm government revenue issues in the state of California. The one thing that agencies need to know is that in their Prop 218 notice, when they go out and notify folks that they're intending to raise rates, they do need to tell everyone in that Prop 218 notice that they will only have 120 days to challenge after the rates become effective. So that is a part of the law. It's an important part of the law. So agencies need to know to include that in their new Prop 218 notice. New requirements started January 1st. But if they do that, then they will have the ability to take advantage of the protections of this law and therefore limit the statute of limitations during which they can be sued on these rates. And we really encourage ratepayers, of course, to come talk to us early during that 45-day period so that we can make any necessary changes to ensure that our rates are constitutional, which is what we always want.
Yeah, no, absolutely. I think that it's important to raise these things when they are being approved. Like, that's part of the reason all these meetings are public, right? So.
Well, and that's one of the things that this law solves is it doesn't completely solve this sneak attack, which is what we're seeing, right? When you come and sue people over a rate that was adopted 10 years ago, how does the agency ever have an ability to avoid that? They don't. This at least shortens that down to 120 days, and we would really ask our public, whenever possible, tell us before we adopt it, and that way we can make the changes that you think are necessary if they indeed are important issues. So hopefully this will reduce exposure for public agencies. Hopefully it will encourage folks who are truly concerned about the price of their utility service to come and speak to the agencies ahead of time in order to effectuate real change.
Yeah.
And I would mention this statute makes it consistent with actually gas utilities and electric utilities. It also makes it consistent. Yeah, and there's two types of rates. The rates you pay every month are what we normally call water and wastewater rates. There's also charges that we call connection fees or capacity fees, and that's usually the charge to join into a system. Those are already subject to 120-day statute of limitations. So in many ways, SB 323 just creates an equal playing field between the water and wastewater industry and all the other utilities, and actually the other parts of capacity usage. So, we think it's a real common sense solution to help minimize exposure and to create more fairness for these agencies so they can have predictability in their rate setting.
Yeah, certainty is certainly something that every agency of this nature needs, considering how much uncertainty there already is out there. So having this is, I'm sure, very helpful. But we've talked a lot about kind of like the utility side of things. I wanted to ask you also about the ratepayer side. How will this ultimately affect the ratepayers? We talked a little bit about it's probably going to require a little more a little more attention paid to your rates at a regular time and paying attention to some of the council meetings and county board meetings and stuff like that, so you know when potential rates are being approved. But in addition to that, what types of things do you expect this will have on, or what types of effect do you think this will have on ratepayers?
I think ultimately this is a big benefit for ratepayers because there is a minimized opportunity for these bounty hunters to essentially reap their bounty. It's going to limit that because, again, those attorney fees are paid for by the ratepayers. Again, if there is a legitimate challenge that is still allowed under this law, it just has to be done within a shorter period of time. So what it does do is it gives ratepayers more certainty, and hopefully it also saves them some money in the long run because their rates will be more closely related to the actual cost of receiving water or wastewater service, as opposed to that cost plus the cost of paying back these attorneys who are really seeking a payday for themselves. And in many cases, I doubt strongly that they were motivated by a desire to protect the consumer. They tend to wrap themselves in the flag, but what we end up seeing is that they're largely out for themselves. And
Hmm.
that's not what we're here for. Our boards of directors were elected to protect ratepayers. All of the staffs were an oath to protect the ratepayers, and that's really what we're here to do. And we think that this law really helps create those protections for the agencies, which by extension protects our ratepayers. And that's our goal. And so we'll see how it works out in the coming year.
Yeah. Well, to your point, this is like by extension, like the more certainty a public agency has on its own things, the more certainty the public has in what they're doing as well. It is a better outcome overall, I would think.
We agree. And I would say there are existing procedures baked into the Constitution, baked into the law, that allow our ratepayers to ask questions, to bring challenges, to ensure that they are only paying their fair share. And that's the sine qua non of our industry. We ask our ratepayers just to pay their fair share of what it costs to run the system. And if they believe that they are not paying their fair share, then we encourage them to come talk to us really at any time, but especially at that 45-day period before a rate hearing is held, because that is, we are giving you public notice and we are asking you to come and tell us if there are any problems. And if we don't hear that there are problems, then typically we move forward and we adopt those rates. So they definitely have an opportunity to challenge. And I just want to make it clear to everyone that this is not to avoid responsibility in that way. What it's intending to do is just create that predictability you were talking about. And I think that's really better, again, for everyone.
Yeah. Well, awesome. Thank you so much, Claire. I really appreciate you taking the time to talk through this, especially for something that could very easily get very complicated. You've made it a lot easier to parse and understand.
Well, thanks. I'm glad. I'm glad. And I really just hope that all of our California agencies are taking advantage of this new law. I hope that they will make sure to, when they adopt new rates, include the notice in their Prop 218, or the 120-day limit in their Prop 218 notice. The law's simple, it's short, and if they've got any questions, they can always call us. But it's a real help for us, we hope, and we think it'll pay dividends over time. So thanks very much for having me today.
Yeah, no problem at all. And for everyone who's watching, check out the video description below for any resources that we have available for you. So until next week, we'll see you then.